Welcome everyone to the Summer United States Supreme Court wrap-up presented by the Legal Impact Podcast and the Warren B. Rudman Center for Justice Leadership and Public Service. I'm AJ Kiersett, host of the Legal Impact and senior media producer at UNH Franklin Pierce School of Law. I highly suggest everyone checks out law.unh.edu/podcast or search the Legal Impact on your favorite podcast service to subscribe and check out our previous episodes. Episodes come out weekly, and this event will actually be released as episodes over the next couple weeks. The show features conversations on current legal topics range from sports and entertainment, constitutional law, international criminal law, technology, and a lot more. So I hope to have a lot more events like this in the future, so be sure to subscribe so you don't miss out. This event is co-sponsored by the Rudman Center, so I'll throw it to Director John Greabe to talk about their work.
Thanks, AJ. Good afternoon, everybody, and thank you for joining us today. As AJ just said, my name is John Greabe, and I'm the director of the Warren B. Rudman Center for Justice Leadership and Public Service. The Rudman Center supplies financial, curricular, and experiential support for our law students who are interested in public service, public interest lawyering. And we also provide events for the community that align with our mission, such as today's event. So we're very pleased to partner with AJ today in order to present this program.
Thanks, John. If anyone has questions as we talk to our panelists, please use the Q&A function that's at the bottom of the call window. I'll ask them at the end of each panelist section. I won't wait till the very end, so that way we can kind of stay on topic as we go, because otherwise this will be quite confusing. So we're going to be discussing at least 7 different cases. Joining me today, I've got Professors Buzz Scherr, John Greabe, Michael McCann, Lucy Hodder, and Dean Megan Carpenter. So very exciting event. I'm very excited to be hosting this today. So first up, we have Dean Megan Carpenter, who has led our law school since 2017. Dean Carpenter is an internationally known expert in intellectual property with particular interests in entrepreneurship, branding, and the arts. She has, whether she likes it or not, become a resident expert in people who end up saying expletives and sit in front of the U.S. Supreme Court. Dean Carpenter, thanks for joining me.
Thanks so much, AJ. Do we follow the George Carlin 7 dirty words prohibition here?
No, definitely not.
We don't. Okay.
No, we're clear.
All right. Okay.
Which is very relevant to our case that we're talking about today, which is Mahanoy Area School District VBL. Can you talk about that, what that case is centered around?
Sure, I'd be happy to. There was a 14-year-old girl who did not make her public school's varsity cheerleading team. And she was very disappointed, as you might imagine, and expressed her disappointment on the social media app Snapchat by posting a photo of herself where she had her middle finger raised with the caption, "Fuck school, fuck softball, fuck cheer, fuck everything." I think that's a quote. Actually, it's definitely a quote.
Definitely a quote.
Yes. So although the snap herself was only viewed by 250 friends and was up for 24 hours, it also some people took screenshots of it and shared it, including with some of the coaches. And she was suspended from the JV cheerleading team for a year on the grounds that that post violated team rules and school rules. So the question here was really, whether that suspension in particular violated her freedom of expression under the First Amendment.
And to start off with, on the school side, I mean, how did they rationalize penalizing a student when they're not on school property? I kind of can understand a higher ed student encountering issues with an honor code violation or a private school, but in a K through 12 public school, it's very surprising.
Yeah, and I think especially when it comes to adolescents, schools are trying to raise good citizens in general, and sometimes their policies are not just directed to academic performance, but also just to being sort of thoughtful and responsible human beings. One of the things that's interesting in this case is that with the advent of social media, we haven't really thought about, what it means to have on-campus speech versus off-campus speech in the social media context. So the case law that we were relying on, Tinker, is really the governing case here, which involved anti-war speech, which you can imagine, means that it was some time ago. That case really, was far before the social media era and was really thinking about kind of a nexus of where there is substantial speech that has a substantial disruption on the school itself, That's how we were distinguishing kind of the ability of schools to regulate this off-campus speech. But then with social media, and as Justice Thomas pointed out in his dissent, sometimes off-campus speech can be received on campus now, and social media sort of tends to skew that concept a little bit. So I think that's where the school was, how it was approaching the issue.
The Supreme Court's ruling on this, I mean, Thomas was the lone dissenter. I mean, can you speak to the justices that sided with BL?
Sure. Really, it was 8-1 in the Supreme Court, which is a pretty overwhelming opinion. Breyer authored the opinion, and one of the things that struck me during the oral argument was a question from Breyer, actually, that he said something like, she used unattractive swear words off campus, and if that using those unattractive words off campus is punishable by schools, every school in the country is going to be spending time punishing students. They would be doing nothing but punishing, I think is what he said. And that, I think, really helps inform some of the opinion that, in his written opinion of the majority. And what they thought, overall was just that they pretty much agreed with the cheerleaders' opinion overall, which was absent a disruption of school activities, disciplining students for expressions of opinion, whether those are made on campus really or off campus, is just never warranted.
It's not like the cheerleader stood up in the middle of a game, putting her middle finger up there. I mean, this was in outside of school property. This was something that happened to have been leaked. It's like the equivalent of a note being passed after class, and then it gets circulated, it seems like.
Yeah, and I think, it was her own device, it was her own time, and it was what she thought was a private circle of friends. And there was no, if we had something that was threatening or violent or bullying, harassing, I think we might have ended up with a different result. But here, she was expressing emotion and feeling, and that's really the heart of free speech.
I'd imagine a case like this will cause many school districts to review their policies and make sure they won't run afoul of new case law around this.
Yeah, I think a lot of us who grew up in eras before social media are thankful that we don't have, records of our own growth in adolescence. But I think that this case in particular has reaffirmed the First Amendment rights of adolescents to express themselves. And it's also good to know that schools can regulate off-campus speech and on-campus speech where there is that substantial disruption and the impact on the school program itself, including bullying and harassing and threatening speech.
Did I miss anything on this, Dean?
I don't think you did. I think you covered it.
Great. Thank you so much for joining me, Dean Carpenter.
Thanks so much, AJ.
All right, we'll move on to Professor Mike McCann. He's the director of the Sports and Entertainment Law Institute, legal analyst and senior sports legal reporter for Sportico, and most recently caught headlines for testifying in front of Congress regarding name, image, and likeness rights. Welcome to the show, Mike.
Hey, AJ, thanks for having me.
So the NCAA seems to be having a rough go of late and maintaining a stranglehold on college sports this past decade, the Ed O'Bannon case being a huge milestone. How does the case NCAA v. Alston continue the pattern of the NCAA losing control over college athletes?
Yeah, it's been rough going for the NCAA. They keep packing the losses on the score sheet, and they lost the Ed O'Bannon case. They lost the Alston case, which I'll talk about in a minute. And they just capitulated on name, image, and likeness, which, as you noted, AJ, stems from Ed O'Bannon's work in terms of players being in video games without their consent or without being paid. A number of states passed statutes that were going to go into effect on July 1st, saying that if there's a college athlete, he or she should be able to make money for the use of their name, image, and likeness, something that the NCAA until July 1st had said was in violation of amateurism rules, basically saying if an athlete gets paid, he or she loses their eligibility, which can mean losing their scholarship, which can mean not being able to afford to go to college. So those are pretty substantial repercussions. And the NCAA last month, talking about name, image, and likeness, was hoping that Congress would pass a federal name, image, and likeness statute that would provide equal rights for college athletes, regardless of what state they play in. This is something that has been proposed for a couple of years. They were hoping that the Senate would come through. I did testify before the Senate, and they didn't come through. They July 1st lapsed, and the NCAA sort of scrambled and put together an interim policy, which basically says It's up to schools what to do. And that creates really asymmetry between college athletes across the country. For years, the NCAA has said it should be one rule for all. Now it's one rule per school, unless they're in a state where there's a statute. And state statutes vary on this as well. For instance, in Alabama, there are prohibitions on college athlete signing with a gambling company, for example. Whereas in Florida, an endorsement deal has to have market value, so it can't be concealing pay for play. So it's really a mess right now for the NCAA. The Alston case is different in that it's an antitrust case. The Alston case began about 8 years ago. And the Alston case began as something bigger than it morphed into, but it began as an attack on NCAA rules that prohibit college athletes from being able to earn income initially for everything, for their athletic performance, for what are now called education-related benefits. And the antitrust argument is that the NCAA and its member schools and conferences, they're all competing businesses. So our college is a competitor of Boston College and UVM and Maine and BU and fill in the blank, literally over 1,100 colleges. They're all competing businesses. So when they join hands to say, none of us can pay college athletes anything for what are now called education-related benefits, that's illegal. And in a 9-0 decision, you heard Dean Carpenter say 8-1 was a blowout. 9-0 is even more of a blowout. A 9-0 decision authored by Justice Gorsuch, saying this is a transparent violation of antitrust law, because schools should be able to pay college athletes education-related benefits. So what does that mean? That can mean cash rewards for doing well in school. That can mean having the school pay for your laptop. It can't be a Lamborghini, which Justice Gorsuch said in his opinion, but who knows what an education-related benefit is. And I have a feeling schools are going to become very creative in labeling things education-related benefits, because schools, at least those that have a lot of money and are trying to put together national programs, they're going to really compete.
And Justice Kavanaugh even said, quote, "The NCAA's business model will be flat out illegal in almost any other industry in America," end quote. And that really stood out to me. I mean, to take the side of the NCAA, college athletics is a messy business where you mentioned, is that balancing act between amateurism and professionalism. Technically, college athletes are there to learn. They're going to college, but it's how much we've always discussed in the past, like being a college athlete takes over a majority of your time when you're at college, most likely.
Yeah, and Justice Kavanaugh's concurring opinion really made the case that this is a cartel. I mean, we don't call it a cartel because we don't like to use that word, but this is functionally a cartel. And what the lawyers for Alston argued successfully is that schools compete for athletics in every way imaginable. They compete for coaches, they compete for staff, they compete to build the biggest stadium, to build the best track, to do everything with an eye towards recruiting the best athlete. Yet they can't pay the athlete himself or herself. So it's sort of like money goes around the thing that they all covet, right? And that argument persuaded liberal justices, conservative justices, and certainly Justice Kavanaugh, who really, and I think his concurring opinion was really sort of a love letter to sports fans, because it was written in a very accessible, sort of highly quotable way. The language that he used was to send a message. Now, I don't know if the other justices would go that far. None of the other ones signed on to his concurring opinion. And to that point, during oral argument in March, some of the justices were reticent about the argument. So Justice Breyer, in particular, was concerned that he basically saying, we don't want judges rewriting college sports. Chief Justice Roberts said this is like the game of Jenga. Once you start to pull things from it, the whole thing will collapse. Justice Thomas also seemed concerned at some point, though he did ask in one of the questions, why is it that coaches can be paid any amount, but college athletes can only be paid zero? I mean, it was a pretty powerful question. So yeah, I mean, certainly there's an argument. I think one issue, AJ, though, with that question is the colleges are all over the board in terms of the scope of their programs, whether they make money. At a lot of schools, college, and I teach an undergrad course, as you know. I have a number of college athletes in that class. They are students. They are students who play a sport. They are not. They're probably getting a fairly good deal, if you will, if they're getting a full ride to college. They're having someone else pay for their tuition. But there are some athletes that go to college that are making a ton for their school.
And it varies a lot from sport to sport. I mean, the top tier football player is going to be doing immensely better than the third tier golf team player.
Yeah, and also, what is education if a player goes to college for a year to play basketball? And really, it's not a year, right? They go to school for the fall semester, and then when the season ends in February or March, they leave and get ready for the NBA draft. I think colleges have to have a serious conversation about what is academic. Why is that even college? If you literally go to school with the intent of staying one semester, I mean, what other person goes to college? And it isn't as if, even musicians, John Mayer, could sign a recording deal when he goes to the Berklee School of Music, and there was no, he's going to lose his scholarship, or what's he going to do next? The Olsen twins go to NYU. Fred Savage goes to Stanford. There was no, how's that going to affect their eligibility? I mean, it's kind of a peculiar institution we have with college sports. And you talk to people from other countries and they scratch their head, because in other countries, they turn pro when they're good enough.
Yeah, I mean, going off of that, I mean, have the leagues spoken up at all about this? I mean, some leagues have these in-between leagues where they don't necessarily want, either they get the feeders from the colleges or they get feeders from a B league or something like that. Have they spoken up?
So it varies by league. So if you're the NFL, what's wrong with college football? It's a free minor league system.
Yeah.
Right. I mean, literally, you're not paying anything for it. They are playing at a top level, especially players in the Southeastern Conference or other Power 5 conferences. Basketball is different. The NBA is now really effectively challenging college basketball. They've invested in their G League, which is a minor league affiliate. And there's now something called Overtime Elite, which is where high school players can turn pro and make what's been reported as up to $1 million a year. That sounds crazy for a US. In Europe, that's not crazy at all. Ed O'Bannon, the player who challenged NCAA, he went to play in Europe towards the end of his career. And he was telling me about, he had a 14-year-old teammate who was a pro athlete. He had a tutor. I mean, that's what you do when you're in that situation. So we do it a certain way, but it does vary by league, AJ, in terms of what their interests are. I remember talking to an NBA general manager about, would you rather a player go to college or go to the G League? And he said, much rather go to the G League, because they go to an NBA situation. They have an NBA coach. It's much easier to evaluate them. If they go to college basketball is very different from the NBA. I have a feeling if you talk to an NFL GM, they're going to say go to college, because that really provides that free minor league system.
What's next for Alston himself? I mean, is it like O'Bannon, where it was essentially the good fight?
Yeah, I mean, so we'll have to see, the NCAA will have to change its rules, and they'll have to figure out what education-related benefit will mean. And what Mark Emmert, the president of the NCAA, said last week is, well, colleges and conferences really need to take over this, which is just such an incredible statement given the NCAA's position for decades. But what I think we will see is conferences become much more autonomous, which is probably the way it should be. Because what we have now is a situation where you have colleges of very different sizes and athletic programs all playing by the same set of rules. Maybe players that go to Alabama and Notre Dame and USC and Miami, maybe their rules should be different than those who go to smaller schools. I don't think that's a bad thing. I don't think that ends college. College sports are going to continue. People love college sports. I don't think they're going to lose fans over it. Maybe they can actually grow the product. And maybe if college players are paid, they're more likely to stick around.
All right. Thank you so much for joining me, Mike. So we'll definitely be talking about many, many cases apparently for the next 12 to 24 months, because these are not going anywhere. I'll let you go so you can get ready for your 1 o'clock event on name, image, and likeness that's happening over at Sportico. Thank you.
Thank you. Thanks, everyone.
To talk about California v. Texas, a case involving the constitutionality of the Affordable Care Act, also known as Obamacare, something Lucy probably hates the reference to, but we're joined by Lucy Hodder, professor of law and director of the Health and Policy Program at UNH Franklin Pierce, as well as at the Institute for Health Policy and Practice. Welcome, Lucy.
Thanks so much, AJ, and great to be with you all. I guess we have, schools and speech and sports and healthcare so far on the docket. What could be more fun?
So how did this end up being a case between two different states? That's fascinating as a non-lawyer to hear.
Yes, well, it's so interesting. It's been an ongoing issue, obviously, challenges to the Affordable Care Act from the minute it was passed. These challenges have been brought, hundreds of them, and it's now been to the Supreme Court 3 different times. So this particular case was brought by about 17 states and then 2 plaintiffs. And just to give you a little bit of the background dynamic, I think we all know this now, the original case and v. Sebelius, there was a challenge basically saying, hey, you can't make us get health coverage. And by the way, if we don't get it, you can't penalize us. That's unconstitutional. We all know the Affordable Care Act has many additional provisions, the Medicaid coverage provisions for expanded Medicaid, all kinds of changes to the Indian health system, just massive changes to our public health system, et cetera. So the focus has always been on this requirement. Can you make us get insurance? And not even everyone has to get insurance, but can you make us? And if we don't, can you penalize us? And in the NFIB case, Chief Justice Roberts pulled together ultimately a majority that said, yes, the penalty is a legitimate tax. And that on that basis, we're going to find this constitutional. They didn't uphold the requirement that states expand Medicaid, but interestingly, people don't focus on that as much. And that's led to real discrepancies across the country as to what states cover people with Medicaid expansion and what states don't. So then fast forward, there was another case, King v. Burwell, which was really hanging on some language about access to subsidies. And then you have this case, which keeps percolating up, and all of a sudden, after what everyone thought was the final conclusion that there's constitutional authority to roll out this scheme where you need to get insurance, and there are various ways to do so, and if you don't, you might get a penalty. Congress in 2017 eliminated the penalty. So there was this aha, and Texas said, aha, now the basis for penalizing people is no longer a tax, and therefore the whole statute must be unconstitutional. And in fact, the lower court said, yeah, it's unconstitutional. And by the way, the whole act is out of here. So
the constant theme politically that keeps
coming up. The constant theme. And if you read all the amicus briefs and everything, that's where, there are 3 issues. Do the plaintiffs have standing to even make their argument? Is their argument valid? Is the statute unconstitutional or the provision unconstitutional? And then what's the remedy? Do you throw the whole statute out, or can you sever that injurious provision? Well, in the latest case, in the Texas case, they were now arguing, hey, we don't have a penalty, but we still have to get insurance, and your ability to make us get insurance is unconstitutional. And the court said, you know what? We're going to kick this out on standing. There's just not an injury here. And so the court sort of put this box around it that says, if you are penalized for not getting insurance, it's a legitimate constitutional tax. We know that already. But if you're not being penalized for failing to get insurance, there's no injury. And the states tried to argue all these sort of distant injuries. Like the states tried to say, hey, if people aren't obligated to get insurance, there are going to be more folks on Medicaid, and that burdens us, and had various arguments about injury, none of which the court bought into. So they really just didn't give the plaintiffs their full day in court. The interesting thing is Justice Roberts, who again wrote the opinion, didn't come out with a resounding affirmation of the Affordable Care Act, yet everybody is interpreting this decision as sort of closing the door to future challenge. Alito wrote a dissent, and it was joined by Justice Gorsuch, and really just hammered the ACA and basically said, the Congress didn't have the power to pass it, which, I think we could spend a lot of time quibbling with the basis for the enumerated powers that were raised in other cases were, just necessary and proper. Also interstate commerce, and then this tax provision. So I think we could have a robust argument about what other bases of the enumerated powers could have authorized the Affordable Care Act, especially as we've seen what kind of federal authority comes to play around the regulation of healthcare in general through the pandemic. So long-winded answer, AJ, to your question, but that's basically what happened. We're hopefully done Supreme Court opinions on the ACA.
Yeah, were you surprised by the ideological makeup of the court with how they ended up ruling on this case?
So I have to say, not really. I mean, it was, this is just one of those super duper statutes, which, I think the dissenters were able to say what they said because they were dissenting. And the court, there's no way Chief Justice Roberts was going to come up with an opinion that didn't really look like it was closing the door. And if standing is where they go, I think probably John Greabe and other constitutional scholars can sort of dig into where they came out on standing. It was a pretty broad sweep, alleging no injury. And not even getting their day in court. So it'll be interesting to see how that part of the opinion plays out over time. I will say there's sort of two consequences to any Supreme Court decision. One is sort of the jurisprudence that comes from it. But the other is the impact it has on the policy. And, we at the health law and policy programs at the law school with the Institute try and keep one step ahead of the policy developments. And we did that again this summer with our event on healthcare sustainability, cost and access and what's going on. And we've really focused on this. And all of a sudden now that the ACA and health insurance coverage is sort of out of the limelight from being argued, where now everyone is addressing the fact that our health insurance is too expensive. Our health costs are too expensive. There's very little oversight of our, health delivery system. So you're really going to see that play out now that we've, sort of cleared some of the other issues out of the way. There's going to be some real focus on actually our delivery system. I'd also say that COVID has really raised up this sort of question that was underlying all aspects of the court's decision. And again, I'm going to defer to Professor Greabe on a lot of this, but it's really a question of the ping pong between federal authority and states' rights. Or state authority or an individual's ability to challenge. And you're constantly seeing with healthcare it back and forth, right? And what area of the regulation does the federal government sort of able to carry the water on, and how about states? We just had in New Hampshire just now an edict from the Department of Education saying school districts and private schools cannot require immunization against COVID or even any of the other requirements that might be associated with it, like masks. So, you're seeing down at very local levels, sort of power grabs around what can or can't be done in the name of healthcare. So very interesting the way the different dynamics amongst the different regulatory authorities play out in healthcare. We just haven't figured out who's responsible for minding the store.
Yeah, definitely. I mean, that's the issue of federalism when it comes to payers and who's Medicare and such is definitely something that's going to be ongoing. And but I'd imagine this is a huge burden to hopefully be able to move past here, especially with the Democrat-controlled Congress and executive branch. That the ACA for now is going to be staying as is, so you can focus on other topics. I mean, do you predict a lot of COVID-19 related lawsuits to be coming through over the next couple of years? A lot of these, especially for the Supreme Court, it takes years for some of these. Like it took 8 years for Alston, which we discussed. I mean, do you predict this is going to be years worth of cases on the health policy side?
So, I think there's going to be a lot more battling sort of politically and at the local level around authorities. I do think some of the states that just don't like the ACA and don't like, being burdened with any extra costs are going to continue to battle the federal government and CMS over resources and what they do or don't need to do in terms of coverage and support for the most vulnerable populations, which has been sort of exposed quite dramatically during COVID. So I see that kind of battle continuing and maybe getting into the court. I also think there's going to be a lot of local constitutional battles just around, vaccination, reproductive health, as we've seen. That's going to be a big area going forward if we're looking at the courts. And the personal rights are going to percolate up again post-COVID as to what can be done in the name of public health and what can't. It's sadly become quite political. We also have all of the very interesting dynamic going on in the life sciences, prescription drug world with some of what the Biden administration's doing to try and relieve some of the prices, both in medical devices as well as prescription drugs, which I think industry is not too pleased about, but that's going to continue to be a big story in healthcare and may get to the courts.
Thanks so much for joining me, Lucy.
Thank you.
All right, next up, we have Professor of Law and Chair of the International Criminal Law and Justice Program, Buzz Scherr, talk about a couple different cases. Welcome, Buzz. Oh, you're muted.
Pleasure to be here.
All right, let's start off with Coniglia V Strom, an interesting case, to say the least, that appears, if you just look at it on the surface, it looks like a Second Amendment case, but it's a Fourth Amendment case. What happened with Edward Coniglia to start this chain of events?
So he and his spouse have a domestic argument, and his wife decides, I'm not gonna stay here tonight. And she goes to a hotel, but she's concerned for him and tries to get in touch with him, see if he's okay, and can't get in touch with him by phone. So she calls the police and basically says what is known in the trade, so to speak, as a wellness check. Could you go just check, see if he's okay? I'm a little bit worried about him. So the police go there and they talk to him and he's fine. And they take him into custody for a mental health evaluation. And then they leave and they take him to wherever it was he was going to get the evaluation. And they leave. And then they come back later and they search the home for guns. Nobody's at the home at that time, but they use what is known as an exception to the warrant requirement, the community caretaking exception to the warrant requirement, which is a relatively new development. It came into being back in 1973. In a case called, I think it's Katie versus Dombrowski. And it basically says, loosely, when the police have concern about somebody's, the risk of harm, that a person may harm themselves or others, they, in the Katie case, they can enter a car. And so in terms of jurisprudence, the question for the court was, can you apply the community caretaking exception to allow the police to enter homes as an exception to the warrant requirement? They had no warrant to go into the home. And the court, perhaps a bit surprisingly, at least in the political sense, 9-0 said, nope, can't do that. The community caretaking exception allows us to go into cars, but it doesn't allow you to go into homes. It's a relatively definitive statement on the part of the court. And it was a unanimous decision.
And that's especially surprising from the politics side of the house. Is unanimous. All the justices on the left and right side of the aisle all say, no, this is a Fourth Amendment issue. You cannot do that.
Yeah, it is surprising. And that at another level, it's interesting and not that surprising, in that there has been a theme for many years on the court, most court conservatives, most often led by the now deceased Anton Scalia, of kind of a libertarian sense of privacy. Scalia was relatively well known for that in some very interesting opinions, majority opinions and dissents. And some of the question was upon Scalia's death, whether that strain in Fourth Amendment, that libertarian privacy strain in Fourth Amendment opinions was going to stay alive. And interestingly, was it going to stay alive in particular with Justice Amy Coney Barrett, who was a clerk for Scalia, and Scalia in many ways was her mentor. And many were curious. I was certainly curious whether she was going to be channeling Scalia or not. But apparently, at least in this sense, they really narrowed down the community caretaking exception. Community caretaking exception has been applied broadly in a lot of different ways, and this is a not insignificant narrowing of the exception.
Commonly known term is red flag laws that we actually talked about in a previous episode.
Yeah, that's I wouldn't say it's a derivative of the community caretaking exception, but particularly in Coniglia, what the police did is the kind of thing that they could do in some states if they had applied to a court. They could do in some states under those states' red flags laws. There's a lot of controversy over red flag laws in that how much due process does the person whose guns are being taken away, how much are they entitled to? Some, including myself, believe that since you're taking away, at least temporarily, a constitutional right, the Second Amendment, they're entitled to a solid dose of due process, a hearing, representation by counsel, ability to challenge the witnesses. So this is different than red flags laws because those are statutory, but this is a constitutional decision. You can't do an end around the due process requirements, whatever they are, of red flag laws by just using the community caretaking exception, because that only applies to cars.
Yeah, I'd imagine there's this. So how much of this decision do you feel like was based around where it took place? I mean, if this took place somewhere else, it'd be entirely different.
It would be different. The court has always honored the sanctity of the home as a privacy realm, that the police have to have a lot of justification to go in there. And when the police don't have to have that justification screened ahead of time by the warrant process, that is, laying out their justification in front of a neutral detached magistrate to see if the magistrate also agrees that they have enough justification, known as probable cause. When you dispense with that, it's going to be very hard under this court's rulings to get into the home. And Lang versus California, the other case we're going to talk about, is another example of that.
Yeah, let's move on to Lang v. California, which is another Fourth Amendment focused case that we'll move from guns to hot pursuits. Can you talk a bit about this case?
Guns to cars, right?
Yes.
Two quintessentially American items. So Lang is, I don't recall how old Lang was, but he's driving down the road with loud music and honking his horn a lot. And this is in California. And in California, it's a misdemeanor to make too much noise that way. So the police start following him, put their lights on to stop him. He doesn't stop until he drives into his driveway and then into his garage. Then the police come up behind him and they enter the garage, and he appears to be quite intoxicated. They arrest him for a DWI, etc. So basically, they, in hot pursuit of somebody who was they believed was committing a misdemeanor, they entered what was the functional equivalent of his home, his garage. And the issue in this case was, in terms of the existing jurisprudence, the Supreme Court has been pretty clear that you can use the hot pursuit exception, which is a subset of the exigent circumstances exception to the warrant requirement under the Fourth Amendment. You can use, if you're pursuing in hot pursuit of somebody who you believe has committed a felony, who have you probable cause to believe has committed a felony, there's a lot more leeway in getting inside that person's home. It had been an open question. They had declined to be very specific in a prior case, whether when you were in hot pursuit of somebody who had committed a misdemeanor, whether you could enter their home. And this case narrowed down the circumstances. The government was asking, the state of California was asking that the court say, whenever you're in hot pursuit of a person who you have probable cause to believe has committed a misdemeanor, you can enter their home, be it their garage or the actual home. And the court rejected that per se rule. They said, no, we're not going to do that. We are going to say that in many cases, if there's a significant risk of destruction of evidence or harm to others, we may well, in that set of circumstances, allow hot pursuit into the home of somebody we think has committed a misdemeanor. But we're going to do that on a case-by-case basis. We're not going to have a per se rule that when you're in hot pursuit of a potential misdemeanor, you can go in their home.
I'm assuming a felony or something like that would be an entirely different situation.
Very much so. So again, a 9-0 ruling. Effectively, there are a good number of concurring opinions, but the outcome was a 9-0 outcome. Interestingly, Justice Kagan wrote the opinion, and what I found interesting is that, in part, she relied on case law from 1791. When the Fourth Amendment was going into effect. It was a very much a Scalia-like originalist way of taking on the problem. My guess is, and only a guess, semi-educated guess is, she used that approach to draw in the conservatives on the court saying, hey, this case comes out even under the originalist way of thinking about this case. It still comes out as you can't, there's no per se rule in hot pursuit of misdemeanors.
Yeah, it's kind of a different way of looking at the court. We always talk about Chief Justice Roberts wanting to side, making a decision when the court split that kind of upholds the importance of the court as something which people on the right tend to give him a lot of grief over. But it goes all the way around. I mean, all these justices have to work together on various opinions, and it's important that they work together to a certain extent.
Very much so. The other thing I would note is it's going to be interesting going forward as the court deals with, there's always Fourth Amendment cases coming up in front of them. And, there's always going to be, increasingly, in fact, privacy cases involving the Fourth Amendment and the scope of what the police can do and the use of Fourth Amendment warrant exceptions. And this is an interesting marker that the court has laid down in these two cases that, we still take privacy very seriously in a world where privacy is under stress in so many different ways. Of course, we in New Hampshire have a whole different approach because we have a information privacy constitutional amendment. So
who wrote that?
It slips my mind who wrote that.
Thank you so much, Buzz.
You're welcome.
All right. Last but not least on the agenda today, we have Professor John Greabe, director of the Warren B. Rudman Center for Justice Leadership and Public Service. You can learn more about the center at law.unh.edu/Rudman. And we'll be discussing two cases that interplay with each other, Fulton v. City of Philadelphia and Tandon v. Newsom. Let's start with the latter. What was the basis for Tandon?
Well, Tandon was it was part of a line of cases that went to the Supreme Court over the course of the nation's encounter with COVID and the many complicated legal and constitutional issues that were raised. So these were a series of cases where churches and synagogues and religious individuals brought challenges to restrictions that were placed on them by public health authorities because of the spread of COVID. It was really interesting to see, and this is probably the area where the switch from Justice Ruth Bader Ginsburg to Justice Amy Coney Barrett, made the most profound difference. So prior to Justice Ginsburg's death, Justice Ginsburg passed away on September 18th of last year. There were a couple of cases brought to the Supreme Court on free exercise grounds. So the argument was this is interfering with our religious rights. And the argument was that restrictions on the ability of churches to gather violated the First Amendment. Both of those challenges were turned away in 5-4 decisions. Now, these challenges didn't get to the court through the whole process of briefing and litigation through a final judgment at the trial court, then appeal to the Court of Appeals or to a state Supreme Court, and then on up to the Supreme Court. Rather, these cases came to the court on the basis of stays that were either granted or denied to request for preliminary relief. This is the so-called shadow docket that's been getting a lot of attention from court commentators because it has become more and more common for significant legal questions to reach the court, not after the full process of full briefing and argument, but rather because a lower court steps in and either imposes a stay on government action or declines to impose a stay on government action. Those sorts of orders are immediately appealable. And recently, it has become more common for, it was actually quite common for the Trump administration in particular, to take cases immediately to the Supreme Court, but also for others, as with the religious groups in these particular cases.
What is that stemming from? I mean, would you say a lot of that stems from just current day, like everything's nationalized, it feels like in current events?
Yeah, I mean, for part of that was in the particular context we're talking about, where it's COVID, right? It's a national emergency. And so quick decisions need to be made on perhaps less than full information. Those sorts of decisions are ripe for emergency challenge and second guessing. But I think there's a phenomenon at play, and this goes back to something that Professor Hodder talked about when she talked about the ACA case. It has simply become more common for lawsuits to be brought by states that are opposed to the policies of the administration that holds power in Washington. We can go back to 2005, a case called Mass versus EPA. The Commonwealth of Massachusetts was given standing to challenge the federal government's refusal to regulate CO2 as a greenhouse gas. Ever since that case, states have taken advantage of their preferred status, at least in some instances, with respect to the standing doctrine, to bring claims to challenge laws and policies with which they disagree. So Professor Hodder talked about the challenges to the Affordable Care Act, to Obamacare, that were brought by, among other plaintiffs, several conservative states that were opposed to the Affordable Care Act. When President Trump took office, everything switched around, and we had lots of litigation involving, among other litigants, states who were, for example, opposed to the so-called Muslim ban, which by the time it actually reached the Supreme Court, explicit reference to Muslim countries was weeded out. And now, we just saw in the news again last week that a federal district judge has struck down DACA. And so, we're seeing this more and more. We're seeing the litigation process being taken over by, among other things, institutional litigants such as states who are opposed to the political party that holds power in Washington. In any event, that's, I think, part of the story. Another part of the story is simply that the membership on the Supreme Court has changed really, really dramatically in the last few years. We start with the death of Justice Scalia in 2016, an election year, the blockading of Judge Merrick Garland's nomination. Eventually, Justice Neil Gorsuch is put on the court, and the Senate does away with the filibuster in order to make that happen. Justice Kennedy then retires. Justice Kavanaugh ascends to the court after a lot of pyrotechnics, as we know. And then, of course, the death of Justice Ruth Bader Ginsburg and her almost immediate replacement just before an election by Justice Amy Coney Barrett. So I think there are lots of parties out there interested in getting their claims to this new court as soon as possible. One of the contexts in which that is happening is claims of religious right, because I think it's indisputable that the court has become far more receptive to claims of religious liberty made in various contexts. I think we are facing a situation where we are on the cusp, at least, of religious organizations having preferred status vis-a-vis secular organizations. Religious organizations are quite clearly fully entitled to seek funding when funding is made available by the government on the same footing as anybody else. So whereas in past years, sometimes, for example, funding for schools was denied to religious parents or to religious schools, the court has made clear that that is no longer permissible under the Establishment Clause of the First Amendment, that religious persons, religious organizations are entitled to seek government benefits on the same footing as anyone else and cannot be discriminated against. However, religious organizations seem to be on the cusp of having preferred status with respect to things like COVID restrictions, where the free exercise clause has come into play and puts them on different footing before a court when they say, hey, this is unfair to us, this keeps us from freely exercising our religion. Again, they are on stronger footing, constitutionally speaking, than the Elks Club or some other secular organization would be in making a similar argument.
Yeah, I mean, a common talking point, and it got this from the court's opinion, quote, the government has the burden to establish that the challenge law satisfies strict scrutiny. To do so in this context, it must do more than assert that certain risk factors, quote, are always present in worship or always absent from other secular activities, end quote, as the government may allow. And I thought that was kind of like summed up what the court thought about what was going on.
Yeah, I mean, if you're going to restrict a synagogue or a church or a temple, or some other religious group from engaging in religious activities, you had better be certain that you are placing similar restrictions on literally everyone else who could be compared to that religious group. That's what strict scrutiny says. And strict scrutiny is almost impossible for the government to satisfy.
And how ultimately did the court end up ruling on Tandon? I mean, what was the outcome?
Well, at once, Justice Ruth, so there were two cases that went to the court when Justice Ruth Bader Ginsburg was on the court. Those cases, 5-4, upheld the authority of local government to place restrictions on religious groups. Once Justice Barrett replaced Justice Ginsburg, 4 more similar types of cases went to the court. And 5-4, all 4 of those cases went the other way. And the Supreme Court held that the free exercise rights of the religious litigants were likely, because again, these are all appeals from injunctions, but were likely to have been violated under the circumstances.
So basically, it seems like we don't know what's going to happen. It's entirely going to be up to the makeup of the court going forward with these cases, at least for the foreseeable. Yeah,
in a lot of doctrinal areas, and a number have been mentioned so far today, we're still sort of waiting to see what's going to happen. Like next term, the court has a big abortion case on its docket. It has a big Second Amendment case on its docket. It's likely to take a big affirmative action case. And we have to sort of wait and see what the court's going to do. I think that we're pretty much already there, though, with respect to claims of religious liberty. And maybe I could talk about the Fulton case at this point, just to bring
that'd be great. Yeah,
that into the conversation. So actually, to set the stage for Fulton, I will make reference. Members who are of the audience who are watching may recall a case called Masterpiece Cake Shop that went to the Supreme Court.
You stole my question, John.
Sorry, what?
You stole my question.
I'm sorry. Well, this was the case. You may remember, if you're a news junkie, you may remember that a baker in Colorado refused to make a cake for a same-sex couple, citing, among other things, his religious beliefs. The case really sort of presented this fundamental question of are religious persons and organizations, again, on a different footing when it comes to following the law, because Colorado had law. There was actually local law that banned discrimination against LGBTQ individuals. And that law was invoked, and the baker was held to have violated that law. He brought a claim up to the Supreme Court, basically saying, I should be exempt from having to follow anti-discrimination laws because of my religious beliefs. Now, there's an old case actually written by Justice Scalia, who was quite a fan of religious liberty, called Smith, that was decided right around 1990. And in the Smith case, again, people who follow this may be familiar with the case. A couple of individuals who were members of a Native American church ingested peyote as part of the sacraments for that church. As a consequence of that, they were fired from their jobs. Oregon had a law saying that if you are fired from your job for unlawful drug use, you cannot collect unemployment benefits. They said that may be fine. That's a neutral law that can be applied to everybody. That may be fine in most circumstances, but you can't constitutionally apply that law to us because we ingested the drug as part of our religious, belief. And we are entitled, or we should be entitled under the First Amendment to do that. And the Supreme Court, in a bitterly divided opinion written by Justice Scalia, rejected their claim and said, no. So long as a law that is neutral and that applies to everybody is not enacted with a purpose of targeting religion, religious people have to follow that law just like everyone else. Okay, so taken to its logical conclusion, that holding in Smith would mean that religious people have to follow anti-discrimination law, for example. And if anti-discrimination law protects same-sex couples, even if that runs counter to their religious beliefs. Okay, so the Fulton case sort of returns us to that scenario. The city of Philadelphia contracts with various social service agencies to run its foster care program. Among the agencies with which it contracts is Catholic Social Services. Catholic Social Services, a Catholic organization, refuses to certify as foster parents unmarried couples and same-sex couples. There is an anti-discrimination law that bans discrimination on the basis of sexual orientation in contracts entered into by the city of Philadelphia. Philadelphia said, you're violating that law, we're not going to work with you anymore. They brought a challenge. So you can kind of see the analogy, right, to the Masterpiece Cake Shop, and brought it up to the Supreme Court. And one of the issues was, should we revisit that old Smith case, that peyote case, which says that basically religious persons have to follow neutral laws on the same terms as everyone else? A lot of people thought this might be the case where Smith is overturned. 3 justices argued for it, but it didn't happen. Basically, 6 justices on the court said, we don't have to decide that right now because what Philadelphia did here is already problematic. Philadelphia allowed for exceptions to its anti-discrimination laws, but refused to grant an exception to Catholic Social Services. That was clearly unlawful. And so again, that also happened, by the way, in Masterpiece Cake Shop. The court kind of avoided.
Once again, both these cases, nothing was fixed. I mean, that's something that people confuse. Like, nothing was fixed with either of these cases. They were simply process issues.
Yeah, that's right. And you could just see the irritation, dripping from Justice Alito's dissent in this case, that they sidestepped once again this question of whether religious people have to comply with neutral, generally applicable laws. That said, I think the handwriting is on the wall. I mean, in a series of cases over the last couple of years, as I said before, the court has made it very clear that religious groups, religious organizations are on the same footing as everyone else. For example, there was a case last year where the state of Montana was making financial aid available for parents of children who would be going to private schools, but did not allow that money to be spent on religious schools. And it invoked a provision of the Montana Constitution, a so-called Blaine Amendment, which said no money should go to secular schools. We actually have a Blaine Amendment in the New Hampshire Constitution as well. And the US Supreme Court said, no, reliance on that state constitutional provision violates the federal Constitution. Again, religious people need to have the same access to government benefits as everybody else does. However, and I think they're just on the brink of saying, however, religious people are in a preferred status with respect to having to comply with otherwise generally applicable laws that nonetheless cut to the heart of their religious beliefs.
I mean, do you see a lot of states or local or smaller jurisdictions looking into how they handle these things going forward now that the court basically is set up how it's going to be for the foreseeable future, and now 2 big cases have come through like this?
Well, yeah, I mean, I think there's a green light out there for states, including our own state, New Hampshire. Part of the budget bill that went, the recent budget that was signed by the governor that contained, of course, a number of controversial provisions that seemed to have not that much to do with the budget. Among them was a religious voucher provision that allows for people to take money that would otherwise go to a local public school district and to use that for a private school, including a religious school. And I think it's just really clear that at least under federal law, that's going to be perfectly okay, and that states aren't going to have a whole lot of leeway to limit free exercise and to expand anti-establishment principles and to, like Montana did. I think states, I think the writing is on the wall, and that these sorts of laws are going to be held constitutional.
Anything else I'm missing on these cases?
Nope.
Except for like a million things that books are going to be written on some of this stuff.
Well, yeah, it's a complicated area, and it's
Yeah.
like that case within a case issue of Smith. So you always have to go back and talk about Smith, which is complicated, and then there's the overlay of it. So anyway, it's a tricky area of the law, but the takeaway is religious rights are expanding.
Thank you, Dean Megan Carpenter, Professors Mike McCann, Lucy Hodder, Buzz Scherr, and John Greabe. And once again, please check out law.unh.edu/podcast or search for The Legal Impact on Apple Podcasts, Google Podcasts, or Spotify to subscribe to our weekly show. And be sure to also go to law.unh.edu/Rudman to learn about the Warren B. Rudman Center for Justice, Leadership, and Public Service. Thank you so much, everyone, for joining me today.
Love doing these with my colleagues.
Yeah, it's fun.
Thanks, everyone.